If we move on to the warrant, again, circumstances that would be murder except where extreme emotional disturbance is involved. And this is from the Arizona courts. And so the backing comes from Arkansas Supreme Court law here. I was a little bit on edge because there was a couple of the jury instructions that said there needed to be like a threat or a brandished weapon. And so I picked one of the other ones that said the evidence that there was some kind of provocation. And I assume that if I dug more into the case law, you could find something where something like this was more applicable, but just given the rules that we were given, didn't really work, but definitely was overwhelmed. He had been taking care of his father for a very long time. This wasn't a sudden rash thing. He was very much on the edge of his seat with grief. And that sudden attempt by his father just to communicate and failing was kind of what pushed him over the edge. So that's what I qualified as a provocation. You can probably guess that if you go to rebuttals, it'd be very reasonable for somebody to say that wasn't enough of a provocation in order to warrant extreme emotional distress. Getting back to some of the other cases that we just saw, I think it's worth considering if you were in that state, you'd probably react the same way. You wouldn't want anybody that you really cared about to go through that. And so, like I said, I think if we dug into case law, we could probably find some precedent for that. But I made the case that the vocalizations and the failure to communicate was the provocation there. And so that's a direct from. Basically, it would be first-degree murder, except for that the incapacitation, severe pain of his father warranted extreme emotional distress, which makes it voluntary manslaughter. So, again, the back and forth of this, I really liked Prezi. It was interesting going back and forth. I had some trouble working with it, but it's a cool way of laying things out. Honestly, I really like Anna's a lot better just because it's kind of all right there. You can go back and forth and see it as opposed to jumping back and forth between slides, but the same basic.
Sure. Do the next right thing so we can see the overall.
Oh, yeah. There you go.
So one of the things I liked about yours was, and it's one of the things about Prezi, it allows you to kind of work through the hierarchical relationships. So when you got to your facts, on the facts slide, then you had those 3 circles, and then that were kind of like the highlight, and then you can drill down into them. Drilling down is probably a good verb for what you can do the way you've set this up. So, it's kind of an interesting thing. And if, as far as showing the Toulmin layout, this is a good way to do that. Comments or questions? Does everybody think that this should be manslaughter?
Yeah, for sure.
Yeah.
I was just. Yeah. Oh snap!
You guys are all just.
I was just gonna.
And it's really neat. Like it's neat and aligned, and like I can see all of the design elements in the presentation. So good job, Mitch.
I resized these white arrows probably 6 or 7 times because I couldn't get them to be the same size. So thank you for appreciating that.
Does everybody think that he should have manslaughter? Does anyone want to make an argument for something else?
I mean, I think we
Okay. All right. I want you guys to go look at the cases and see what the judge has decided.
Yeah, can you hear me?
Yeah.
Okay, cool. I was saying that I think the law doesn't specifically, wouldn't quite say that he was guilty of manslaughter, but it just feels weird to charge him with anything else.
Yeah. I kept asking little questions like, how many of you have had people that were dying, and do you really think everybody should go shoot them to put them out of their misery?
Yeah, I kind of thought that the shooting him in the head was kind of extreme.
Yeah, I mean, he shot him more than, well, that exacerbates it. The fact that he shot him as many times as he did
that kind of lends to the emotional distress factor in the case. I mean, it's like the only other option if he was going to do it is to like one flew over the cuckoo's nest and smother him, and that's terrible. It's prolonged. I mean, this is a terrible choice to have to consider in the first place, but when you're facing a long-term illness that just isn't getting better and you get the no code diagnosis, I mean, you hit rock bottom, and I think that, if anything, constitutes emotional distress. But that's just my personal.
I mean, it's definitely emotional distress, but is it the kind of emotional distress that we want as a policy to promote the shooting of a person for? So I don't think it's a good policy for a government or a society, which is what the laws and the whole judicial system do, for them to promote
executions
this kind
is
of
a
a
little dark.
response to this sort of emotional distress. Because in fact, many, many, many of us have gone through similar things, and the last thing we want in the world is everybody going through these kinds of things, going out and shooting people. Now, and this is why the mercy, an actual statute for mercy killing is, if you're going to allow that, you need to have a statute that protects people to do that. Anyway.
Yeah, and the statement that was made I'll keep this brief, in the case circumstances, whatever you want to call them, the facts, was that there had been an agreement, like, don't let me struggle to breathe, but you can't prove that once someone's dead. I mean, unless it's in writing, and I mean, what kind of, are you going to get that notarized? Like, what are you going to do with that? So,
and even still, does it say shoot me in the head if that
right.
happens?
Yeah.
No.
Most
likely not.
Another piece that's kind of against this is the fact that he went to these efforts to get a gun and bring it into the hospital, which, why, I mean, it did not sound like he just normally carried a gun around. He specifically went to get it. So that all gives much more of a sense of intentionality about.
True, but I guess the time period, because he received the news for the no code, and it was like 24 hours later that he did this. So, 24 hours of hearing that your dad is just going to beat Comatose, period, and that's the end of the story. We're not even going to try and save him. I mean, yeah. Okay. I don't know. I mean, again, that goes down to personal opinion until you get down to precedent, and we didn't really get to look at that yet.
Yeah. Okay, so can you let's see, Caden, you've been very patient.
Yes. Okay, so
Dr. Mattson, do you know if Arkansas has a statute on physician-assisted suicide or not?
It does not, although at this most recent legislative session, there was a proposal, but it didn't get anywhere on it. I think it's unlikely. Well, who knows? Arkansas legislature is unusual. So, but there was somebody who proposed it, and I don't know how within the I think it's manslaughter. There is a thing that says I think it's manslaughter, maybe it's some type of negligence, that helping somebody do physician-assisted suicide is a crime of some kind. Can't remember which one it was on. Okay. Caden. So Caden, what did you used Adobe Illustrator?
Yes, ma'am.
Okay.
Okay. So this is just the overview.
Before we start, could you tell everybody a little bit more about this case? Because this wasn't in the assigned readings. Not everybody read it.
Okay, this case was about a guy who was with, basically it was 3 men. There's no real notice of how well they knew each other. Basically, 2 men at least went in armed into a gas station and attempted to rob it at closing time. The owner of the establishment shot one of the robbers, and the third guy just kind of ran in later and was shot at. And basically, because of the fact that his supposed accomplice was killed, then there was the issue of him being of the third man, the defendant here, being charged with his death because of just the way the law works out. And I thought that was really interesting, and yeah, that's why I chose this one. So let's see. This is just the overview. Give me a second to change it to a view that we can actually see. So basically, the defendant was present during and is believed to be an accomplice to the robbery. His acquaintance was actually killed by the owner during this. So the claim is that he would be guilty of manslaughter. And looking at going to the law, we have here that the fact that he was defended, the fact that he was present with other people is what kind of clues him in, and the fact that someone died in the course of them fleeing the scene of robbery. And so this the section here under evidence explains how that works out, because it normally seems a little strange that someone could be charged with murder while being unarmed. But as a rebuttal, this section, there is some doubt as to whether the defendant was actually an accomplice. In fact, there's testimony from another one of the people who was involved in the robbery that it wasn't him at all, that the owner misidentified him. And here is the qualifying statement is that that the defendant will be guilty of manslaughter if the state can prove that he was actually an accomplice to the robbery, because that's really what's most in question here.
Yeah, so it's a factual dispute essentially, proving that he was an accomplice, and then the rest of it follows from that.
Yes, I mean, because the rest of the case is really harder to dispute. The only part that we could say is whether or not he was actually meaning to be a part of the robbery, which in his case, he says that he was had no intention of even being there. He got out of the car after realizing that he had sleep or was passed out in the car after drinking. Realized his friends weren't there, so he walked into the gas station to see, what was going on. And so that was his testimony on his case. I thought it was just interesting because actually had a relative who was in a similar situation. No one died, but when I found out when I was really young, the fact that you could get convicted of a crime in which you actually kind of had no part in besides being around was really frightening to me, but it's just the law works, I guess.
Why do you think there is such a law?
I mean, I guess there's the idea that that basically, I guess the idea is that if you're hanging around the kind of people who might commit crimes, or I guess just people trying to say that I was there, but I had no part in it.
Yeah.
But it's one of those laws where it's just so easy for innocent people to be kind of caught up in something, just by being around. And it's hard when, so like I said, so in this case, the defendant, the person who really got charged with anything, he was the only person in the situation who was unarmed. Like the other two men that went into the gas station were armed. The gas station owner was armed, but it turns out the one unarmed guy was the one who goes to prison. So it was just interesting, just kind of how that can work out, which is why I chose it. But just for my graphic, I know that I went a little bit differently as far as include like
You went a little what?
labels. Sorry?
I'm sorry, what did you say, Caden?
Oh, I was saying that just about the graphic is that I didn't go with the text labeling. Instead decided to use illustrations. I didn't want it to get like kind of there's too much text. I have a harder time. The linear format works best for me because I have visual tracking issues. But
I was a little vague on explaining, on saying who your audience would be for this activity. And if you were really going to do this for the jury, you probably wouldn't have used the Toulmin terminology. That's more of an academic set of terminology in order to analyze things and help us understand. You might, although you might not use the terminology, but you certainly could use it to lay things out. And I mean, Caden, you're using the same things to lay things out, so, and you're going through the logic. Was there an alternative crime that he might be guilty of?
No, it was really straightforward because of the fact that he was unarmed and didn't actually the only option that he could be charged with would be manslaughter in that case.
Okay, so he's either manslaughter or not guilty.
Correct. Yes.
Right. Okay.
Is there any room for like a self-defense, something or other mixed in with this, or obviously that's not what we're looking at in this unit, but as far as a real world situation?
I mean, I guess the issue is that like it might be self-defense if we were talking about the owner who actually shot the guy, but the defendant here was unarmed during the whole time. He was just simply supposedly an accomplice. So.
Did it say what happened to the other guys, the ones who were armed?
One of the men died, which is why there's the case of manslaughter, and I believe the second one was, I believe the case says that he was in prison at the time of the trial due to charge. So we're not really sure. We did know that he testified on behalf of the defendant, saying that it wasn't actually him. So it doesn't really say what the other guy was charged with because he was already in prison for something else.
Mm-hmm. And I imagine the store owner would, if they had decided to charge him, he would have argued self-defense.
Yeah, for certain. But he wasn't the one that got shot, was he? Because it was one of the actual armed robbers that was shot, and he got charged with manslaughter because of the felony in progress.
Right.
Okay. So yeah, that would be the store owner's defense, but
right.
As far as his,
it sounds like they didn't
stroke a bad luck.
I'm sure they discussed things. Okay, so that is all that we have. It turns out that I did not start recording until the middle of Mitch's.
Oh.
So
I'm so relieved. I'm sorry.
you're relieved. But I did, however, create a sheet that has all of the links to all of them. So what I'm going to do is share it with everybody, and then you can go look at them at your leisure, the different ones that everybody did. And I certainly apologize if you were wanting to be recorded. So it is 9:20, and I want to be mindful of your time. So I am. Oh, hi. Who's this? Latanya, who's this?
Oh,
This is my little one, Lacey. She wanted to smile at you guys.
We're glad to see you.
hi.
Hey, Lacey.
Okay, so I will post this sheet that has links to all of them, and you can look at them at your leisure. And and I will post the recording, but the recording started in the middle of Mitch's. This is the problem with user error, so I apologize. If you want to tinker with it and work with it, you are welcome to do it. I'm really impressed by all of these. They were just really amazing jobs. Everybody incorporating both your legal and your rhetorical skills at document design. So good job. And I really feel like you've got most of you have a good handle on the legal reasoning process. So it's looking really good. And I look forward to figuring out how to do this mock trial. I'm still sort of muddling through I did a mock trial last year, but it was for an on-campus course, and I have never tried to do it for an online course. So I haven't quite figured out how we can do it, but I'm confident something will come through to me soon.
You'll figure it out.
So,
And just
but in the
let us know.
meantime, just go start looking at all that material and thinking about it. I do know I'm going to randomly assign sides, so don't decide which side of the case you want to be on.
For anybody who's
Switching it up, huh?
For anybody who's actually like interested in the public domain and like not coursework syntax, there's a site called the Public Domain Review, and they basically just like a blog site on all these things that are public domain, and they kind of just distill the best of the best and write these really cool articles on different topics. So I've done a bunch of work for several of my classes on public domain because I think it's fascinating. So that's a really cool site.
Well, maybe later you can actually send me the link and I'll share it. It's an area that's really interesting. And I really think on the legal area, it's a particularly interesting thing. I mean, because, you would think that all these legal decisions and court rules and court's opinions and everything, because it's all part of a government, it's the, Article 3 courts, it's all, it should be open access. And yet, up until recently, you had to pay a fortune in order to get access, or you had to go to the physical library. And so it's just very changed, and it's an interesting thing. Okay, so I will see you all online. Any questions before I go? Okay.
No.
None.
Good night, everyone.
Good night.
Bye. Good seeing y'all.
Bye.
Bye.
I did see.